Thank you. Please be seated. Good afternoon. Okay, we're here on the 1:30 docket. Mr. McKinney, your name is first on it.
Judge, I have Angelica Walker that I've called for in the courtroom for 23 CF 1508.
Okay, why don't we pass on Ms. Walker and we'll see if she gets here later.
And the other person I have this morning is Antrahol James, who I've also called for in 23 CF 1916. I do have a matter in the courtroom that is off the docket if the court wants me to
Yes, sir.
address that. That is Mr. James Ward.
Let me pull up also Zoom.
And that's you, right? James Taylor Ward?
Yes, sir.
Yes, sir. Hello, Mr. Ward.
Judge, Mr. Ward is present before the court in 23 CF 1151, and he's present before Your Honor today because he missed court for pretrial on the 11th. And he has shown me documentation that he was at the emergency room at Twin Cities on that day.
Mr. Ward, just over lunch, I saw the letter that you sent to the court.
And Judge, he is present before the court, and we're going to request that the court consider recalling the capias and placing him back on the pretrial docket. I will note that he does have 2 misdemeanor cases in which looked like it was the same day.
Okay. And you saw doctor's reports or hospital reports?
Yes, Your Honor. I did see documentation from Twin Cities that he did go to the emergency room on the 11th of September.
Any objection from the state?
No, Judge.
Mr. Ward, the capias is withdrawn. Thanks for doing that. You know, always tell me about it sooner than later. It works out better. Thank you, sir.
Thank you.
And Judge, that's the felony case. He does have the same warrant for the 2 misdemeanor cases. Would the court be in a position to recall those capias and place him on the next available docket?
Yes, sir, I do.
Thank you, Judge. Madam Clerk, do I need to announce those case numbers?
No, but one of them he doesn't have the KPS in because that was set for a different docket day. So that docket day is on 10/9. They weren't tracking together.
So 10/9 would be his next court date for misdemeanor court, Madam Clerk? Okay, you understand? So you go to misdemeanor court on 10/9, and then you make an appointment to come see me, and then you come back on November 13th. Okay?
Thank you.
Thank
Thanks,
you,
Mr.
Judge.
Ward. Mr. Lyons?
Your Honor, we call Rafael Lopez Rodriguez first.
Yes, sir. Yes, ma'am. What's your name?
Ana Rodriguez.
Thank you, ma'am. Nice meeting you.
Thank you. Nice to meet you too, sir.
Thank you, Madam Clerk.
Thank
If
you.
you'll swear in the interpreter.
Do you swear or affirm that you'll make an accurate, complete, and impartial interpretation from the Spanish language into the English language and vice versa relative to the costs and under consideration of one part?
Yes, I do.
Thank you, ma'am.
Your Honor, Mr. Rafael Lopez Rodriguez is approaching the podium. We do have a 7-count information. We will waive the formal reading. Enter a not guilty plea. Ask that this remain on the November 13th docket. But I can tell the court that the court is going to be seeing Mr. Lopez Rodriguez sometime in the month of October on a bond motion. These are, in my opinion, patently absurd bond amounts for Mr. Lopez Rodriguez. We'll address that later, though.
Mr. Lopez Rodriguez, when you came out this morning for just a couple minutes without an interpreter, I can't imagine what that felt like to you, that we just look at you and we start talking in a language that you can't understand, and then all of a sudden they take you back in the back. In my court, we'll never do anything of substance without you having an interpreter and without you understanding that, okay? Thank you, sir. I'll see you no later than November 13th, but if Mr. Klein sets a motion hearing next month, I'll see you then.
I will probably see you sometime in the next 2 weeks. Okay?
Thank you, sir. Anyone else for the interpreter? Okay,
Not until 2:30, Judge.
okay, thank you. Anybody else have anybody in the gallery? I saw that gentleman walked in. Mr. Kinney, is that your client?
Yeah, I have Keita Nicholson, Your Honor.
Good, okay, that'd be good.
Ms.
Thanks.
Nicholson is present and approaching. Yesterday, the state filed a one-count information against Ms. Nicholson. This morning, I filed a written not guilty plea for her. We will also enter a not guilty plea today and ask that this remain on the November 13th docket.
Okay,
And I still do not feel properly represented.
okay. Well, let's get a little water under the bridge first. Let's see what Mr. Kleins does on your case, and then if you want to file a motion for me to find that Mr. Kleins is rendering, what I have to find for you to win on that is that Mr. Kleins is rendering ineffective assistance of counsel.
Because there's a video that proves I did not do what the charges are. The video proves that the charges are not true.
Okay,
You can read the charges and look at the video and they don't match.
okay. Well, Mr. Kleins needs the discovery or before
But
he
he's
can do
already
that.
told me he would tell them to press charges, and after talking to me for an
I got
hour
you. Yes,
yesterday
ma'am.
about movies, and other stuff, did they press charges?
Okay, I remember this from last week,
Yes.
right?
Yes.
Yes, ma'am.
I've been here 3 times with no info.
The information was filed yesterday, probably while I was on the phone with Ms. Nicholson. I think it was filed at 1:45 p.m.
Okay. Ms. Nicholson, I'll see you back here on November 13th at 9 o'clock.
And even though the video doesn't match the charges and proves that I'm
Correct. It's
innocent.
premature for me to determine what the facts of the case are. That wouldn't be fair to you or the state.
Okay, so what are the charges now again? Neglect?
Child neglect, you have a copy?
Yes,
of it?
ma'am.
Actually, it's right here.
Cruelty toward a child. Child abuse. Yes, ma'am.
Because I need to understand it. Well, you said neglect.
I'm sorry, it's child abuse.
Child abuse.
Okay.
Okay.
Well,
Thank
I
you,
know
ma'am.
I didn't do it, so
Okay. Thank you, ma'am.
I appreciate your time.
Jenna Linton?
Don't see Miss Clinton. Okay. Okay, then, Rachel, you just want to call the folks in the back? Okay. 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 Oh, what about the gentleman that had the, what I would call Harrington rods in his back that I said I would call first? Let's do him. Thank you.
Right, I can have number 17 and 8, also number 18.
And his name, Rachel?
Seymour Short is
Thank
his
you,
last
ma'am.
name.
Yes, ma'am.
He's an unrepresented judge.
23 CF 1856.
The information was filed as a photo on,
Hello, Mr. Seymour Short. Okay, so I previously entered a not guilty plea on your behalf, but then, Madam Clerk, you say that, Okay. Mr. Seymour Short, you're hiring a private attorney?
Yes, sir.
Okay. Yes, ma'am. Ms. Davis?
Judge, I have 3 different notices that I would like the record to reflect that I'm serving personally on the defendant at this time. Notice to seek prison releasee reoffender, notice to seek habitual felony offender, and notice to seek habitual violent felony offender.
Yes, ma'am.
So, Mr. Seymour Short, make sure that you give those to your private counsel, okay?
Yes, sir.
And I'll see you and your private counsel. If you hire one, if you don't hire one, fill out the financial information for a public defender. But I'll see you back here no later than November 13th. If your attorney wishes to file a motion before that date and have a hearing, we can do that too.
Yes, sir.
Okay.
Thank you, sir.
Thank you, sir, if you'll take those sheets with you.
Have a good day.
Thank you, you too.
Jennifer Morales
Thank you.
with Mr. Klein.
Your Honor, I believe Mr. Morales will still be considered under oath, I believe. We were in the middle of taking testimony when,
Okay. Okay, yes, sir.
so Mr. Morales, where are you originally from?
I was born in Pensacola. My mom moved us to Arkansas for 10 years when I was a little kid after her husband committed suicide. And when her and my dad got back together, we moved back down when I was 16, 17 years old. So I've lived here pretty much my entire adult life.
Okay. How old are you now?
34.
I don't think I have any other questions.
Okay, to the state.
No questions, Your Honor.
Okay, argument, Mr. Klein?
Your Honor, Mr. Morales is asking the court to reduce this cash or professional bond to a signature bond. He has appeared in court. I don't have any notes that he's ever failed to appear in the 22 CF 2511 case. This new charge actually stems from, I believe, a probation search of his residence. And I'd probably anticipate a rather quick resolution to this, but in the meantime, Mr. Morales' main concern is the roommate that he mentioned before lunch, essentially looting his house. So the house that belonged to his dad, I don't know what all's in the house, but I know Mr. Morales would legally seek to evict this individual, but that seems to be his main concern. So we are simply asking the court to consider reducing the previously set cash or professional bonds in 23 CF 1936 to signature bonds.
Thank you. Mr. Gonzalez?
Yes, Your Honor. I just want to bring to the court's attention in the 4623 CF 1936 case, as Mr. Klein's alluded to, this was this incident stemmed from a search for probation. I just want to point out in the underlying case where they were going to search, Mr. Morales arguably had more knowledge that they were going to come than any other probationary person that I've known of. He was actually instructor. The whole point of us and the way that we handled that case was that we gave him time to get rid of the weapons that he had agreed to. He knew the probation was going to come search, and yet when they go to search, he has an alleged 2 grams of what field tested positive for methamphetamine, 3 grams of suspected methamphetamine, 2 more grams of suspected methamphetamine, and some drug paraphernalia. I also believe that one of the field tests actually came back positive for the presence of fentanyl. Given that his bond wasn't even revoked in that underlying case, which is a whole other discussion, the state feels as though $10,000 a cash or professional bond is more than reasonable here, and we would request that that bond remain in place on this case, given that it is very clear from this fact pattern that Mr. Morales knew that probation was coming, and he still didn't have the thought process to say, hey, I don't need to have anything illegal when probation is coming. Given this, we feel like that's a clear indicator that Mr. Morales is not amenable to following the laws of the state of Florida, and we would respectfully request that this bond remain in place because we do feel as though it is reasonable.
Thanks, Mr. Gomez. Yes, sir.
Only thing I would point out, Your Honor, is this offense report in the 23 CF case references that these bags were found in a common area of the house, in the foyer kitchen area. And this is a house
But
that,
under that, it says post mortem, the defendant admitted to ownership of the above item.
I understand. But that second sentence after that, Your Honor, where it says the defendant admitted to selling, Mr. Morales strongly denied that statement when I asked him about it. So that's it.
Okay. Mr. Morales, if you'll talk to your attorney before you testify.
Mr. Morales just wanted the court to be aware, and obviously I wasn't present when this happened, but Mr. Morales is claiming that Mr. Blythe actually admitted to the ownership of the specific substance that had fentanyl in it.
Okay, thank you. Mr. Morales, I can only go on what the evidence is before me, and it's very limited. It's the sworn testimony from the arrest report. And based on that, respectfully, your motion to reduce bond is denied. So it'll remain at the $10,000 cash or professional. So I'll see Mr. Morales on November 13th. Is that?
Actually, he's going to be back before the court on October 12th for his arraignment in 23 CF 1936.
Okay, I'll see you on October 12th.
Right? You can still bond out.
Okay, that's fine.
You mean, you can still bond out.
Rachel, who's next?
I think Mr. Koch has a few after us.
Good, Mr. Koch.
Good afternoon, Judge. If I could call Mr. John Reinhold, who's present and approaching, Your Honor.
Okay, thank you. Hello, Mr. Reinhold.
I very much apologize for my attire. I came straight from working in dirt.
Okay. Yes, Your Honor. It looks like the state did file formal charges yesterday. If I may ask just for an offer from Mr. Reinhold, if there's one available.
Judge, just to be clear, so Mr. Reinhold had reached out to my office, to my assistant. So we had in our system that Mr. Reinhold was unrepresented. So because of that, I did send Mr. Reinhold a copy of the plea offer form. I have forwarded those emails to Mr. Koch today when I realized that no, he has actually had an attorney, but the correspondence that we had, when I looked in our system, it looked like that he had no attorney, so. At this point, the offer from the state is going to be, we would dismiss count 1 in exchange for the plea. On count 2, the misdemeanor count, it would be an adjudication of guilt, 12 months probation. You'd have the court costs, letters of apologies to Officer Jasmine Scott and Benjamin Crawford, no alcohol and random breath test.
Your Honor, if we may pass this up, if I could talk to my client about this offer.
Certainly. Yes, sir. Mr. Reinhold, is your dad's also named John Reinhold?
Yes, sir.
Okay. When I was a kid, he was, and this isn't the disclosure to everybody, but when I was a kid, he was the coach for caravan camping when probably YMCA or something took a bunch of folks up to Sliding Rock and into Georgia, and your dad was the camp counselor for that. So I just wanted to disclose that.
I don't think.
The reason why I'm asking, Your Honor, is that there's a potential conflict here. Mr. Phillips, Spence Phillips, is going to be here at 2:30 to be sentenced on a case involving who I suspect is Mr. Reinhold's father. So we'll look into this away from the courtroom, but I just kind of caught the name. And
The response that I had gotten from Mr. Reinhold was that he wanted to accept the offer, just to make sure that we're clear.
That's true.
So,
okay,
yeah.
heard the name and it,
Yes, sir.
because it's top of mind, because I talked to Mr. Phillips over the lunch break, so.
I understand. Okay. So you're going to bring back Mr. Reinhold a little bit later this afternoon?
Yes, please,
Good.
Judge.
Thanks. Thank you, sir. I'll see you
Thank you.
then.
Yeah, okay. Judge, I also have a Jared Smith present approaching, Your Honor.
Oh, Mr. Smith.
Thank you. Your Honor, I was just handed the information in this case. If we could enter a formal not guilty and waive formal reading of the charges, and if we keep this set for the pretrial on 11/13.
Okay. Mr. Smith, I'll see you back here no later than November 13th at 9 o'clock. Okay? Thank you, sir.
Okay.
Dina Robeson. Actually, I have Adrian Sanders here.
Okay?
Thanks for sending.
Any other questions after reading? No. Okay. Your Honor, if I may, just have my client sign the plea form? Okay. I'm just gonna put the court costs like we talked about right here. Okay. And if you could sign right here. And then just date it, it's the 21st. All right, excellent. I'm just gonna sign on there.
Hello, Mr. Sanders.
Yes, sir.
Judge, this will be a change of plea, no
Okay.
contest.
Yes, sir.
And it will be counts 1, 2, and 3 be adjudicated guilty. It'll be 36 months of probation. All counts still run concurrent. On probation, my client must complete a substance abuse evaluation, any recommended treatment. There'll be random urinalysis. Thank you. Client must complete 24 hours of community service. 1 year driver's license suspension. A letter of apology to Deputy Anthony Jennings. Court cost, Your Honor, of $615 and defense costs of $150. Counts 4 and 5, Your Honor, to be adjudicated guilty and credit time served. If I may approach with the plea form.
Yes, sir. And then there's $40 per month cost of supervision, correct?
Yes, Judge.
Okay, thank you.
Remember that $40. $140.
Okay.
$548 for court cost. I'll make that correct.
Okay.
Thank you.
Mr. Sanders, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Sanders, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Sanders, I think they amended it after you signed it, the cost to $548, but that's less than what was in there before.
Okay.
You agree to that?
Yes, sir.
Mr. Sanders, I do accept your plea. You're adjudicated guilty in each count. You're sentenced to time served on counts 4 and 5. You're sentenced to 36 months probation in counts 1, 2, and 3 to run concurrently, run at the same time. You'll need to submit to a substance abuse evaluation within 30 days from today.
Okay.
Begin any treatment if it's recommended within 60 days from today.
Yes.
Submit to random urinalysis. You can't have any drugs without a valid prescription. You'll need to perform 24 hours of community service work. Your driver's license is suspended for 1 year. You'll need to do the letter of apology to the law enforcement officer. You'll need to pay the court costs, $150 public defender's fee, and the $40 per month cost of supervision.
Yes, sir.
Thank you, sir. Good luck to you.
Thank you, sir.
Dina Robeson.
Thank you. Hello, Ms. Robeson.
Judge, I was handed information that has been filed in the 2023 CF 1872 case. We'll enter a not guilty.
Yes, can we talk a minute?
Your Honor, may I have just one brief moment?
Yes, sir.
Thank you. Thank you, Judge.
Thank you. So, Ms. Robinson, I'll see you back here no later than November 13th. If your attorney sets a motion hearing before that, I'll see you then. Thank you, ma'am.
Take this. Your Honor, if I just may be excused to talk to the
Yes, sir.
preschool.
Sir. Mr. Kleins?
Your Honor, I have a Jenna Linton on the docket, 23 CF 1470. However, in reviewing benchmark, Ms. Linton was given a signature bond, and the signature bond set the court date for October 12th in Crestview in this case.
Okay.
And then there was also returned mail, so I don't believe that Ms. Linton has noticed that she needs to be in court today. I would just ask that the court continue this to the October 12th date, and I will instruct our Crestview public defenders, if she shows up for that court date, to send her south.
Good. So October 12th at 1:30.
Yes, sir. And then I don't have anybody else on the 1:30 docket.
We have not.
Okay. Is Holly Mason present? Holly Nicole Mason, 23 CF 1897. I don't see Miss Mason. This was noticed for 1:30. It's now 1:59. What does the state seek?
State would request the KPS, Your Honor.
KPs will be issued for Miss Mason. That means that they'll arrest Miss Mason, bring her before the court, so we appreciate y'all being here. And it'll be the first appearance, Judge, will determine the bond. Okay. Yes, sir. Mr. McKinney?
Judge, I have Angelica Walker in the courtroom.
Hello, Ms. Walker.
Ms. Walker is approaching. In 23 CF 1508, we would acknowledge the receipt of a one-count information, waive its formal reading, enter a plea of not guilty, and ask for this to remain set on the November 13th docket at 9 a.m.
Ms. Walker, I'll see you back here November 13th at 9 o'clock. Stay in touch with Mr. McKinney.
All right, thank you.
Thank you, ma'am.
And Judge, I also have Antrell James on the docket in 23 CF 1916. And in reviewing that case, while I was sitting at council table, it looked like it had been transferred from another division. Madam Clerk, would you please check and see if notice was sent for today's court date?
Judge, at this point, the state is not going to ask for a capias.
It looks like there may have been a transfer from the other division and no notice sent, so I'll just enter a plea of not guilty for Mr. James. I don't want him to get a capias.
Good.
And then ask for this to stay on the 11-13 docket.
Yes, sir. Madam Clerk, who else do we have?
I have, Eli Lisco for the out-of-state fugitive.
Mr. Lisco, who's pro se. Eli Paul Lisco, 23 CF 1890. I don't see Mr. Lisco. a no bond capias will be issued.
Judge, it's just a fugitive from justice. As soon as Mr. Gomez comes in, because I can't speak on that case as far as what the status is of whether the other state's coming to get him or not. If that's why he's out of custody, I don't know. That was Mr. Gomez that had gotten with the jail to follow up on that.
So what do you want to do on Mr.
Just pass it for just 1 second until Mr.
Okay.
Gomez comes back.
Yes, ma'am. Thank you. Madam Clerk?
That's all I have for
Okay.
1:30.
Mr. McKinney, anything else on the 1:30 docket? Or that you want to take it this? Mr. Peterson?
Yes, sir.
Are you ready?
I am, sir.
Okay. Let's see if everybody else is ready, Mr. Peterson. Before we do Mr. Peterson's case, the case that the interpreter's here for, is everybody ready for that?
No, Your Honor. That's going to be ASA, Ms. Michelle Sandberg.
Okay.
And I believe that that's going to be for the victim's mother to testify at that sentencing hearing, Mr. Chairman.
Good. Thank you, sir. Mr. Peterson?
Yes, sir. We're here on Christine Webster case, 2021 CF 2924,
Yes, sir.
on her,
Request to terminate probation?
yes,
right?
early.
Good.
She was placed on probation, I think, June the 12th of 2022 for 6 months community control and a year and a half of probation. In addition to the community control, she's paid all of her fines and court costs. She wishes to go to Israel, which she's already signed up for and paid $1,500, of which may not be refundable. And she's leaving to Israel on April 27th. If you could release her like April the 1st, that would be wonderful. And that would only be less than two months early.
Okay. To the state?
Judge, the request to terminate supervision early is, as Mr. Peterson has explained, it's based on a trip that's planned for next April. So at this point, the state would feel that this motion for relief is premature. We'd ask that this hearing be continued to a later date, a little bit closer to that time period, if that's the only basis that we're discussing for her to be terminated from supervision early. This was a case that there was quite a bit of work that went into it in preparation for the plea agreement. So at this point, the state would object if Your Honor was inclined to make a decision on the motion today. The state would object at this point. It's been just over a year, and this is, as Mr. Peterson explained, this is a case that was 2 years worth of supervision. So we would ask that the supervision be maintained at this point, and then it can always be refiled at a later date.
Judge, in response to that, if I may, we are asking that the termination be done as of April 1 of 2024.
If she doesn't violate between now and then and doesn't commit any new law violations.
Yes,
right?
sir, absolutely.
And so as of right now, she's completed 1 year of a 2-year probationary sentence.
It's very close to that, sir.
With those caveats, does the court have any objection to, basically it's saying that it would automatically terminate on August 1st if there weren't any violations and new law violations?
For April 1st.
For April 1st.
Next year.
Yes, ma'am. Probation?
I just want to bring to your attention to the court that she is a VFO. And her officer put a case note in here in the computer that he does not agree with an early term because of the VFO status.
Okay. State, what do you wish to do?
Judge, at this point, we've explained our position.
Yes, ma'am.
We oppose at this moment.
First off, when I saw your letter, I printed it off, highlighted what was in there. I was glad that you did it sooner than later and brought it to the court's attention. September 7th. Tell me how long have you been going to Liberty Church in Gulf Breeze?
Since November of last year.
Okay. And so why is it such a big deal to do this trip?
It's never had the opportunity before. It's the first time it's come up for me.
Okay. I mean, it is strange. You know, I have concerns about the macro picture. Do defendants in the future say, I want to go on a cruise in 6 months and I want an automatic termination of that? And then the court starts doing that. And then if there's a violation between now and then, you know, it was a waste of time. It was a waste of resources of the court. I understand that you'd like that certainty. But I must agree with the state at this point. So respectfully, I'm not admitting or not granting your motion. But if you want to come back closer to April 1st, then you can certainly do that. You know, again, it's just kind of strange but I praise you for planning further out.
Judge, there is a matter that she has to pay the money up front, and she has to pay the $3,900 up front.
Yes, sir.
And
but again, Mr. Peterson, when I look on the macro picture, so I have a line of people out the door that want to do a trip to Europe, and they want a guarantee from the court that their supervision is going to automatically terminate early if they don't violate. Basically, I'm adding a new term to the plea agreement between the state and the defense. We all know that the court has the ability to modify probation, no matter what the plea agreement says, but really kind of flies in the face of the agreement if I'm doing it prospectively.
if it turns out that she does not have any further violations, can we set a court date around April the 1st of next year?
No, sir, I don't even know if we have a calendar on April 1st. I guess we probably do. But no, sir, if you'll just file a new motion and then schedule it for a hearing. Talk to Ms. Davis before that time. If Ms. Davis agrees to it, you don't have to have a hearing.
Okay.
I understand that the position to put you in, but I also have to be protective of the system. And I just have concerns of opening that gate. Okay. Thank you, ma'am. Good seeing you, Mr. Peterson.
Excuse me, sir?
Good seeing you, sir.
Good to see you, sir.
Thank you. Okay, good. Yes, sir. Mr. Reinhold.
Yes. Yes, Your Honor.
Yes, sir.
Speaking Ms. Reinhold, there is a conflict in my office, and I would be requesting orally right now to be withdrawn. That being said, I did just discuss the offer that was stated on the record, and Mr. Reinhold would like to accept that offer if possible once withdrawn from the case, Your Honor.
Understand. Thank you. So your motion to withdraw is granted. Mr. Reinhold, do you understand that you have the right to be represented by an attorney?
I do.
And that if I accept this plea, that you would be waiving that right?
Yes, sir.
You'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down. So, Mr. Reinhold, you'd be waiving your right to a jury trial. You understand that?
Yes.
You have to say it verbally.
Yes.
Okay. Count one would be dismissed. You'd be adjudicated guilty. Have you ever been adjudicated guilty of a misdemeanor before?
Yes, sir.
You'd be adjudicated guilty of a misdemeanor, sentenced to 12 months probation. Did you have time to talk to Mr. Koch about what that entails?
Yes, sir. I'm familiar with it, unfortunately.
Okay.
Experience.
And you'll have no alcohol during that 12 months and submit to random breath tests. Do you understand that?
Yes, sir.
you still wish to enter the plea?
I do.
Mr. Reinhold, I do accept your plea. Count 1 is dismissed. You're adjudicated guilty on count 2, the misdemeanor. You're sentenced to 12 months probation. You'll need to prepare the letters of apology. You'll need to pay the court costs, $150 public defender's fee. The misdemeanor, is there an advantage of Mr. Reinhold being supervised by other than probation? Other than it's $10 more?
But there's a better possibility of Mr. Reinhold having some more step-down opportunity than typical reporting status with state probation. So the state would not be opposed to JCS probation.
Okay. Mr. Reinhold, did you have any opportunity to talk to Mr. Koch about that?
We did not, but I'm familiar with both types of probation, unfortunately.
Okay, which one do you want to be on?
I believe JCS would be
Okay.
in my best interest.
Okay, so 12 months probation, JCS will supervise it. I believe they charge $50 per month. You'll have no alcohol during your supervision and submit a random breath test. Okay?
Yes, sir.
Thank you, sir. Good luck to you.
Thank you.
And your dad's still alive? I take it from other words that the PD was saying?
He's doing well.
Good. Please tell him I said hello.
Yes, sir.
Thank you, sir.
Your Honor, the state's going to be announcing dismissal of that case. That was a fugitive from justice. I believe he was picked up by, I can't remember what state it was. But.
Okay. So Mr. Lisco's case is dismissed. Anything else for the 1:30 docket? Still don't have everybody here for the 2:30 for the interpreter, I take it? Because we're waiting on the prosecutor, right?
Your Honor,
Yes, sir.
defense is ready on Dylan Sloan. That is set for 2:30, but we are ready.
Yes, sir. Let's do it.
Actually, the state. Okay, I don't want to speak that parallel.
Judge, I don't have anything else further if I can be excused.
Yes, ma'am. Okay, so on scheduling, what I've got down is Marsh on September 28th, Thursday.
Yes.
I've got motions in Sabio and also Mueller on Friday, correct? The 29th. Then I have Mueller and Machino going on Monday, so we'll figure out that, I guess, on the 29th, depending on if Mueller's continued based on the motion to appear via Zoom, right? Is that what we're going to do?
Yes. I'm just telling you now, if we're not continuing it now, it's not fair to the state if we have that motion and he loses to not have the trial. That'd be kind of.
I'm just going on what y'all were saying earlier this morning.
Oh no,
I'm planning on
that was
going
this
to
morning before you told us that we're having a trial. But I don't think there's any grounds for a continuance, regardless of what happens at that motion.
Okay. So Mueller's going Monday, Tuesday, and Wednesday. If Mueller goes, then I'm not having Machino on Monday and McLean on Tuesday.
And so the court's aware, and I talked to Mr. Gomez about this. Earlier this week, I had listed a notary public as a defense witness in anticipation of her just testifying.
Which case?
Mr. McLean.
Okay.
In anticipation of her just to testify to authenticate a particular affidavit. Over the break, Mr. McLean informed me, and she did mention, she made some comments when I talked to her earlier this week, but I didn't really follow up because I just was trying to nail down whether she could testify. There was a discussion that she had with the person who gave this affidavit, and I informed Mr. Gomez, I'm never going to try to pull the rug out from under any attorney. So there was a minor change in circumstance, and I think it would only be fair if the state wanted to depose this notary to see what she has to testify to. So
Is the state moving for a continuance on McLean?
Yes, the state will move with a continuance. I just think, I don't see how the state can be tasked with having to balance the possibility of having two trials on the same days and then like having just like at the very last minute drop this case and then go to that one. So I would request a continuance on the McLean case.
And the defense would join in that request, Your Honor.
Okay, so Mr. McLean's case is continued.
But I will call him today and instruct him to continue making efforts if he's interested in trying to hire private counsel to do that as quick as possible.
Yes, sir. And then I'll see him on November 13th.
Yes, sir.
Sounds good. Thank you. Okay, yes, ma'am. Thank you.
So you're tonight excused.
Yes, ma'am. Thank you so much, because you're not doing Machino, correct?
No, I have walls on that
Friday.
very last Friday.
Yes, ma'am. I will see you then.
That's all I got.
Okay, thank you. Hello, Mr. Sloan. Good afternoon. I'm doing well. How are you? Mr. Sloan, that chair goes up and down. If it's too low for you, you can pull the thing on the side, or if it's...
I always sit as low as possible, so thank you,
Thank you, sir. Yes, sir. You're welcome. So Mr. Sloan's case is 23 CF 1565. You'll give me a second to grab my homework. Got it. Motion for release on own recognizance or on the alternative to reduce bond, correct?
Yes, Your Honor.
First off, let me just tell you that when I was doing my homework, I wrote down well-written, and then at one point I wrote down good, and I struck that because I thought that may come across as being biased, which it certainly wasn't intended, but it's a well-written motion, Mr. Koch. Thank you.
Thank you, Judge.
Yes, sir.
And the defense does have one witness to call in this
Please.
matter, if I may.
Yes, sir.
Miss Cindy Sloan, who's present and approaching Your Honor.
Ms. Sloan, if you'll please come to the witness stand.
Stand right in front of this chair, face the clerk, and raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Okay. Now, this is, he's like all the way up to that microphone, and he's gonna just, okay, I'm a little short there.
Thank you, Judge. Ms. Sloan, if you may state your full name for the record.
My legal name is Cynthia Arlene Gay Sloan.
Yes, thank you, Ms. Sloan. If you could go into your, how do you know Dylan Sloan?
Well, I gave birth to him about 29 years ago, this past August 12th.
Okay. And where do you currently reside?
I live in Panama City, Florida, Bay County.
Okay.
Do you need my physical address?
Yes, please.
3906 Ereno, E-R-E-N-O, Court, Panama City, Florida.
Excellent. And how long have you lived in the Panhandle, in this area?
All my life.
Okay, and how long?
Or in Florida all my life, except 1 year in second grade in Alabama.
Okay. And if you, how long is all your life in Florida?
I just turned 66 this past September, or the Saturday,
Yes.
16th.
Yes, ma'am. And could you go into the relationship with your son growing up? Did he live with you?
Absolutely. I had him full time. The only challenge I had was getting him to wake up for school. And so the day he graduated high school was the best day of my life because I didn't have to do that anymore. But we have a very close relationship. He has a heart of gold and has literally given the shirt off his back to someone in need.
Okay. And does he have any siblings that live in Florida?
He has a sibling. She does not live with me.
Okay.
Live with him.
Where does she live?
She's 1.7 miles from me in Lynn Haven.
Okay.
Which is an adjoining town.
And does she own a home there?
She does. She owns a home, and she is a registered nurse in the emergency room. She's a charge nurse there and has been doing so for several years.
Okay. And before this, the arrest, the incident, did Dylan live with you, or what was that relationship like?
Yes, very good. We're very close.
So he lived with you?
He lived with me.
At the house?
Yes. There's only about a couple of years of his life that he has not lived with me, but most all of his life he's been with me.
Okay. Now, does he pay you rent?
He does not, because he was a full-time college student taking extra credits, And he had his own expenses, car payment, car insurance, cell phone, and so what little he made, which was maybe $100 a week, went toward his expenses. And as you know, going to college, I thought was the better thing for him to do.
Okay, certainly. Now, you said college is, what year was he, or what?
I think he was finishing up his second year at Gulf Coast, and he was taking extra credits, very difficult classes, or he got special permission to go into certain courses because of how highly he scored in both math and science.
Certainly. Now, due to the arrest of Dylan, do you have to pay anything on his behalf?
Yes. His dad and I have stepped up, and we're covering his expenses, his car payment, his car insurance, his cell phone.
And if you estimate, just what kind of number is that per month?
$317 on the car, $169 on the car insurance, and $175. So 3, 4, 5, 6, 7, almost $700 a month.
And that's just to be clear, that's since he's been arrested, you had to pay about $700 a month?
Correct.
Okay. Are you currently employed?
Yes, sir.
If you could just kind of briefly go into that.
Absolutely. I work for Bay District Schools. As of October 1 will be my 19th year. I'm slated to retire in a year. I am a data specialist, so my responsibilities are filing state and federal reports. That's what I do. So I make sure that our data is accurate and that the reporting that is required by law gets done in a timely and accurate manner.
Okay. And if Dylan is released, is he welcome back into your home?
Absolutely.
Okay. What kind of, if he goes back to your home, will you be there monitoring, or how will that moving forward look like?
Pardon my comment, I'll take this from my daddy, but I'll be on him like white on rice. I'll make sure that he toes the line. Whatever he has to do as far as check-ins, preferably in Bay County, it's closer for us. But whatever he has to do, requirements, he will do.
Okay. If this court orders him to submit to random urinalysis,
not a problem. He's never had a drug or alcohol issue, but if he needs to do that, absolutely, no problem.
Okay, so any condition set by this court of GPS or showing up to court dates, you would assist in this?
Absolutely. Now, the GPS may be a challenge financially depending on what the cost is.
Okay.
But if it's required, we'll somehow make it work.
Okay. Is there anything else you want this court to know in regards to this hearing?
I can't think of anything. He's a good young man with a promising future. Okay. And I firmly believe in him.
Okay. Thank you. No further questions, Judge.
To the state?
Just a few, Your Honor. Ma'am, you mentioned your employment earlier. Is that Monday through Friday?
Yes.
What are your approximate work hours?
6 a.m. until 2:30 p.m.
Thank you. I don't have anything further.
Thank you. Mr. Koch, any redirect?
No, Your Honor.
Thank you, ma'am. Thank you so
Thank you
much
very
for
much,
being
sir.
with us.
Appreciate it.
Mr. Koch, any other evidence?
No further evidence, Your Honor, just argument.
Any evidence from the state?
No, Your Honor, just argument.
Thank you. Mr. Koch?
Yes, Judge. As stated in the motion, my client is being held on 3 charges: the obscene communication, $75,000 bond, cash professional; distribute obscene material to a minor, that's $75,000 bond, cash professional; and then use of a two-way device to facilitate a felony, and that's at $50,000, cash professional. In the motion and the testimony, I was trying to get a couple points: threat to community, ties to the community, and then overall assets and liabilities. If I could start with the threat to community. My client, prior history, he does have 1 arrest, and I stated in the motion, it's out of Bay County. It was for domestic violence battery, and that case was ultimately, no information filed on that, so ultimately dropped. That is the only blemish on my client's record. So I don't want to characterize it as spotless, but other than that arrest, that's all my client has had on his record. I also like to take note of the Osceola County pretrial risk assessment. They conducted at first appearance, Your Honor. And as it's in the case file, they ultimately scored my client as a 4, and using the chart that they use at the jail, it's he scores the low, and as a nonviolent felony, it does recommend ROR or signature bond. And I know this is discretionary, but I just want to point that out to the court, Your Honor.
Thank you.
Also ties to the community. If released, my client will live with his mom, who's been here her whole life. He does have a sister that lives 1.6 miles away. And Ms. Sloan, just want to say she's been in contact with my office, and she was here at 8:30 this morning. She does her due diligence and loves her son, and he will be living with her if released, Your Honor. Also, going back to release conditions, I say in the motion, speak with my client, I have no objection to any release conditions this court imposes. I did list a couple on 13 and 14 with no objection to weekly reporting, house arrest, community control sanctions, GPS monitoring, random breath tests, urinalysis, and imposing any condition of no unsupervised contact with minors, not to be where minors congregate, no access to the internet. The defense has no objection, Your Honor, to any of these conditions being imposed. The basis of this motion was my client just can't afford the bond. No objection to any conditions, and of course, I already went through his threat to the community, but speaking with Ms. Sloan, my client was making at best $100 a week. Of course, that job is not there anymore. He was a full-time college student. Speaking with these pretrial conditions, the $5 a day GPS, my client having just $700 in car insurance liabilities on the outside, together, my client can't afford the bond. So I am asking, Your Honor, to change the bonds to a signature bond so he can be released from custody, of course, with any conditions, and that would be my argument. Judge.
Thank you, sir. Thank you. To the state.
Judge, we would have an objection to signature bonds at this time. As mentioned, there's $75,000 cash professional per count for each of the 3 counts. I know the court is aware with these type of allegations and how these cases work. However, we would note in this particular case that while engaging with sexually explicit chats, that these lasted 5 days, so it was a longer chat. Photos were sent that were visually similar facially. And the phone number that was used to chat with the undercover officer posing as the 14-year-old is the same number that actually was provided to pretrial services as the contact number. Defendant's guideline score is 27 months, Department of Corrections, the maximum of 15 years. And as his mother mentioned, she would be willing to help supervise him. However, she did note she works Monday through Friday. Given the sexual nature of the charges, his lack of ties to Okaloosa County, difficulty reporting in person should he return to Bay County, and that he scores Department of Corrections time, we don't believe signature bonds are appropriate in this case. And we would ask for the intensive level D supervision to include GPS and the other pretrial conditions that were previously imposed at first appearances.
In other words, the state wants the bonds to remain the same, but add those conditions. Is that what you're saying?
Judge, at first appearances, level D pretrial to include GPS, no internet, no unsupervised contact with minors were already imposed, so you just continue to request those should the court be inclined to lower or reduce the bonds to signature.
Thank you, ma'am. Mr. Koch, finally.
Judge, it'd just be to reiterate the one blemish on his criminal history I like to kind of characterize as that strong ties to the Panhandle with his mom, his sister, and her willingness to accept him at her residence. And this defense and my client and his mom, no objection to any condition imposed by this court. It was just making $100 a week at best. He just can't afford the amount. Thank you, Judge.
Mr. Sloan, if you'll just give me a moment, I want to look at the arrest report. Okay. I did read through the motion and those terms in there. Let me just get this. And Mr. Sloan never traveled, correct? Talked about it, but didn't go?
That's correct, Judge. There's just the solicitation, transmission of harmful material to a minor, and then unlawful use of a two-way communication device.
Thank you. Mr. Sloan, I'm sure I don't have to tell you, but very serious charges against you. I don't say anything to you where you have to say anything. I don't want you to say anything because it may hurt your case. But I want you to understand where the court's coming from.
Yes, sir.
It's very interesting, the pretrial risk assessment scores. Interesting how all that comes about, as Mr. Koch says, something that is just basically like an argument, and the court has discretion how much weight it wants to give that. But it does give us an indication of what your past is, and Mr. Koch outlined that very well. If the allegation had been that you had actually traveled somewhere, it would be a very easy decision for the court. Your motion for release on your own recognizance or alternatively reduce the bond is granted. All of your bonds will be signature bonds. You will have to report to pretrial every week. You will be on community control, meaning house arrest. I'm not going to impose the GPS. One, if you're on house arrest, then you're going to have to be at home. So, and you can't access any internet. You can't have access to any internet. So knowing that you'll be at home that period of time and not having access, that provides the protection to society that the court looks for. You have no unsupervised contact with any minors, and you won't go anywhere where minors congregate. So when will I see Mr. Sloan next?
Judge, he is scheduled for the pretrial on November 13th.
Okay. Mr. Sloan, you do need to reside with your mom.
Yes, sir.
At that 3906. Is it Alino Court?
Judge, may I have some
Sir. So I'll see you back here November 13th. Yes, sir, Mr. White.
One second. Your Honor, may I ask just a question to clarify?
Sure.
The first one would be with the no internet. I did speak with Mrs. Sloan, with the court, just because I don't want any kind of violation to remove any internet from that household, just to clarify on the no internet, or?
I mean, he can't have access to any internet. That would certainly be the purest way to make sure that he doesn't get into trouble later, yes.
Yes.
By pretrial saying he has access and therefore they violate him.
Okay, thank you. And the last question would be, of course, follow community control. Is there any, can they work with a work schedule if he can get employment?
Absolutely. If he's going to school, well, he can't go to minors, so he'd have to only do school with adults. But yes, sir, he can certainly do work. So talk to pretrial about that subject to your work schedule.
Thank you, sir. Thank you.
And just to clarify, I know with pretrial, if it says no internet, one of the big things to look for is internet-capable devices. So phones that have internet are no.
Okay, thank you.
Thank you.
Thank you, Judge.
Sir. Thanks, Mr. Sloan.
Thank you, Judge.
Thanks to your mom being here too. Thank you, Ms. Sloan.
Thank you, Your Honor.
Okay. Who do we want to take next? 2:30 docket? Anybody? We lost our interpreter.
Matthew Gunn, if that's okay. I know Madam Interpreter's here for that, and I think we
Okay.
want to
Yes.
allow her the opportunity to lead us.
Good. Yes, ma'am. I agree. You want to get her out of the, she in the back?
She's out talking to the one she has to interpret for,
Okay,
the victim's mother. But I'm happy to go get her for you.
please, yes, ma'am.
I'll start off there.
Good afternoon.
Good afternoon, Mr. Judge Brown.
Big Miller.
Yes, sir, I do.
I'm gonna wait for them to get into the room before I start talking. Okay. So, you.
Is that your witness or the statement?
No, it's gonna be the state's witness. Just waiting for everybody to get into the courtroom. Judge, I am Jason McKinney, and I represent Mr. Matthew Caleb Gunn in 20 CF 2299. This is a felony violation of probation. Mr. Gunn had admitted the violation of probation to Your Honor and set the day as a sentencing hearing. There is no agreement with the state regarding sentencing. If we cover some basics on the front end, he was sentenced originally as youthful offender and sentenced to a 6-year probationary sentence by Your Honor at a sentencing hearing at that time. I did provide a sentencing letter that I believe the court should have received yesterday, detailing the defense position related to Mr. Gunn.
Yes, sir, I did.
That references a letter provided by Career Source in the Workforce Now Career Advisor. Did the court see that in the record?
I did not.
May I approach with
Please.
a copy of that? I have a
Yes,
copy
sir.
for the state as well. I believe it's been filed into the record.
And Your Honor, the state has already had the opportunity to review this letter.
Okay, thank you. Thank you, sir. Okay, yes, sir.
The sole reason for violation in this case was a misdemeanor arrest for petty theft. Mr. Gunn has entered a plea to that. He received a time-served sentence. He has prepared a letter that he wishes to read at this time. Would Mr. Gunn be allowed to?
Want it under oath or not?
Yes, Your Honor.
Okay. Mr. Gunn, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Judge,
Sir, you can put your hand.
now I'll lead him through questioning. Mr. Gunn, everything you just heard me tell Judge Brown about how we got to here standing before him, is that right?
Yes, Your Honor. Yes, Your Honor.
And obviously, I know everybody gets nervous in the courtroom. Are you nervous standing here today?
Yes, sir.
Okay. Take a deep breath. Did you write a letter that you wish to read into the record?
Yes, sir. Yes, Mr.
Judge, may he be allowed to do that at this time?
Yes, sir.
Your Honor, I take full accountability for my actions. Due to my recklessness, I've not only derailed my life, but my family's life as well. I left the mother of my children to assure the role of a mother and a father. I deprived my children of a father, including my newborn, who was 5 days old at the date of my arrest. Due to my actions, my newborn son doesn't know who I am. I've been incarcerated for almost 4 months. I've reflected on my decision and put into perspective what's at risk. I know in my heart that this isn't a road I would like to go down. Moving forward, I will always take into consideration what I have to lose before I act. With every move I make, I will keep the sake of my children's future in mind. If reinstated, I plan to immediately regain employment at Longhorn Steakhouse. In the same timely manner, I plan to get in contact with my case manager at CareerSource to take my remaining modules of my GED exam. Upon completion of my GED, I have full intentions of enrolling in the college courses for cybersecurity with the help of CareerSource and Kathy Gavitt at Northwest Florida State College. With the help and support of my probation officer, Maylani from CareerSource, Kathy Gavitt from Northwest Florida State College, my employer, and my family, I look forward to successfully completing my probation and impacting my community in a positive way. I plan to continue my therapy sessions with Dr. David Rosenberg and look forward to continuing to share my story with troubled youth, promoting anti-violence and gun safety. If allowed by this honorable court, I would love to contribute to my community through community service hours. Concluding my statement, I apologize from the bottom of my heart to the Sanchez family. Hugo was the truest friend I've ever known. If I could, I would sacrifice anything to bring Hugo back. I relive that dreadful night every time I close my eyes. My heart aches for your family, and I can only wish one day to be forgiven. I would like to also apologize to my family, the state of Florida, Walmart, and to this honorable court for my actions. I ask for one last chance to prove myself as a father, a son, a student, a citizen, and as a member of this community.
Judge, Mr. Gunn, how old are you, sir?
I'm 22 years old.
If you were released or reinstated on your supervision, do you have a plan to help you get situated in the community?
Yes, Your Honor. I've reached out to Mr. Tom with Jada House, and he's let me know that if I'm released and reinstated today, that I'm welcome to go to his program and reside in a structured environment with the teachers of Jesus Christ, and I'm sorry.
Mr. Gunn, and especially the last 4 months and seeing what happened to you with just a minor thing from Walmart, do you understand how small decisions can have big impacts?
Yes, Your Honor. I apologize. Yes, Mr. McKinney. I've reflected on my actions probably every single night, thinking of my children and what I've left behind and what I have left to accomplish.
And especially related to the misdemeanor petty theft from Walmart. Why?
It was the beginning of the month and I just paid my bills. My oldest son's birthday was on April 5th and I didn't have enough to make ends meet to provide him a good birthday. And it was a dumb decision.
If Judge Brown gives you another chance to reinstate your probation, are you going to take that for granted?
No, sir. No, sir.
I have no further questions for Mr. Gunn.
Thank you. To the state, questions for Mr.
No questions for Mr. Gunn, Your Honor.
Any other evidence, Mr. McKinney?
No, Your Honor, just argument.
From the state, evidence?
The victim family would like to address the court.
Judge, may we sit at council table?
Yes, sir. Sir.
And then the state has argument after the.
Okay, if you want to call your first witness.
Raquel Sabella, Your Honor.
Thank you. Please come to the witness stand.
Just needs to stay right here, raise her right hand and face the clerk.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes.
Here, just put it all the way up. And she can go to the microphone if she wants.
And just for the record, for this case, Madam Interpreter was previously sworn in. Yes, ma'am. Questions?
Ms. Sabella, what is your relationship to Hugo?
Mi hijo, my son.
And I believe she would like to make a victim impact statement at this time.
Yes.
The reason why I think Matthew should spend more time in prison is because he can be free and enjoy his life, and he take away that opportunity to my son, Hugo. Matthew also say that he will be a good example for other young people in the society. And he will be an example for good manners and behavior, but how will we be able to do that if he violates the law? So this has affected my family and myself a lot. Hugo was everything for us. My grandkids meets their uncle.
Okay, I'm sorry, that last sentence was what? Or was it what?
The last sentence, Your Honor, was this affect my family and myself a lot. Hugo was everything for us, and my grandkids miss their uncle.
Okay, I don't understand.
So that's this statement.
Okay, if you'll read it one more time, I'm sorry, I'm just missing.
No, absolutely. So this has affected my family and myself a lot, and Hugo was everything for us. My grandkids miss their uncle.
Gotcha. Okay, got it. Thank you, ma'am.
Yes, Your Honor, absolutely.
Any questions for the mother?
No questions for Ms. Bella.
No, Judge. Thank you so much for being here. Thank you.
Oh, 2 days, 3 years, my son.
Thank you. Any other evidence from the state?
No other evidence from the state, just argument, Your Honor.
Yes, ma'am. Mr. McKinney?
Yes, maybe you want to reapproach the podium?
Yes, sir. Sir.
Judge, as stated in my letter, Mr. Gunn was placed on 6 years of probation by the court. The circumstances that happened in the original case are tragic. We recognize that. Today we are talking about a violation of probation, and the sole reason for the violation of probation is something that Mr. Gunn took responsibility for. It was a misdemeanor. He has entered a plea agreement and received time served for that. Mr. Gunn said it was a dumb decision. It put his family in peril. That's absolutely true. What Mr. Gunn is asking for is for reinstatement of his supervision. The probation officer, the person who's closest to Mr. Gunn, recommended that his supervision be reinstated to include 6 months of community control and to impose 50 hours of community service work.
6 months community?
6 months of community control and to impose 50 hours of community service work. Basically, it's a modification.
Okay.
Mr. Gunn, if awarded another chance by this court, intends to further his education and try to provide for his family. So Mr. Gunn is sincere in, I believe, his approach to the court. In my conversations with him, since I wasn't the original attorney who handled Mr. Gunn's case, that was another attorney. But since the time I've had with Mr. Gunn and speaking to him, he's been nothing but sincere. So I believe that he wishes to chart a productive path forward, and that would start with the court awarding him a chance today and reinstating his supervision, even if the court modifies it to include additional things such as community control, community service, things of that nature.
Thank you. To the state.
Your Honor, to note something the defense said, this would be another chance. Mr. Gunn wished to chart a productive path forward at his last sentencing, and he did not. This violation, his score sheet shows 115 months in the Department of Corrections. Now, this court, the state agrees with Mr. McKinney. This court sentenced him as a youthful offender, and the court would be limited by that and only able to sentence him to 72 months Department of Corrections, but that's what the state is asking for. And that's because, and to put it a particular way, there's another court in this circuit that I've had the opportunity to watch, and they say every time that probation creates a contract between the court and the defendant. You follow the law, and you get to remain free. And Mr. Gunn broke that contract. It may be a misdemeanor offense, but it's a theft offense. It's an offense of dishonesty. And he broke that contract by committing that new offense. He's not on probation for theft. He's on probation for manslaughter. He killed someone. And this court gave him a great opportunity by sentencing him as a youthful offender the first time. He's 22 years old now. He's old enough to know better. And he doesn't qualify as a youthful offender anymore per the law. You have to be 21 at the time of sentencing. And he's not that age any longer. We don't believe that he deserves a downward departure. There's been no evidence shown that he should get a downward departure, just asking for a modification. And the fact that he was a good employee, he has a family, anyone who would face hardship, or that the guidelines seem too harsh, none of those are really valid non-statutory reasons for a downward departure.
But for a VOP, I don't have to find a downward departure, correct?
A VOP, the court does need to find a downward departure unless the court makes a modification.
Right, okay, thank you.
It's the court's job to punish an adult court, and we're in adult court. The guidelines are there for a reason, and were he not a youthful offender, he'd be facing almost 10 years. The state believes that 72 months in the Department of Corrections for breaking this contract with the court is the appropriate punishment for violating probation for manslaughter. And we ask that the court sentence him accordingly.
Thank you. Mr. Gunn. I have 1,000 different thoughts. Let me use some of the words that the state used, because it kind of helps put it into, frame it in a way of different things that I'm thinking. You breached the contract. You had the contract as far as probation, you breached that. Is years in prison, is that the just remedy for that breach of contract? And it's not just breaching a contract in some absolute. The court looks at, how did you breach the contract? If it was just a black and white, you breached the contract no matter what it was, here's what the sentence is, I don't think that would be justice. Monday night, one of the Florida Supreme Court justices spoke to the Florida Bar and talked about the discretion that the trial court has, and said at the appellate level, they have no discretion. Theirs is right and wrong. They don't have the discretion that the trial court does. It says you broke the contract and therefore you shouldn't be able to remain free. I don't think I have to tell you, the possibilities of what the outcome of today may be, the huge downside possibility from a relatively minor breach of that probation contract. State says given a great opportunity, no question, I agree. But did you give up all of that opportunity by, again, a relatively minor transgression or breach of that contract? Mr. Gunn's adjudication last time was guilt?
Yes, Judge.
Mr. Gunn, you're adjudicated guilty. Your current supervision is reinstated and modified so that you're sentenced to time served, which approximately four months. That's enough of a consequence, even in relation to the horrible crime that was committed initially. That is enough of a consequence for the degree of the breach of the contract that you caused. I'm not going to modify it for community control. That doesn't seem to be just in relation to the breach. So it's just time served. Your current supervision is reinstated with the original terms and conditions modified just to include that time served. You'll need to pay the $150 public defender's fee and the $100 cost of prosecution. Please remember the feeling that you have right now. Looking at the pain on your face immediately reminds me, but nowhere close to the degree of the pain on the mother's face when she was testifying, when she said, "It has been 3 years since my son died." When I was doing my homework, I read back through the horrible facts that happen, that give rise to this case. But, there's nothing that the court can do to make the mother or the family whole. But I just don't see a shoplifting charge as a way for the court to say, yep, this gives me the time to put you in prison forever or for years. I just don't think that's justice. You do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, Your Honor.
Thank you, sir. And to the family, thank you so much for being here. It means a lot to the court. We'll take a 10-minute recess and then we'll come back and finish it at the after.
All rise, please.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Ferdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
The Cottage Formalwear, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalwear. We're located at 648 North Wilson Street. Call 850-682-2446.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ.
Ms. Glow. And I have, well, I'm waiting for, we have a sentencing, but it's not.
Mr. Klein, you ready? Ms. Glover, come on up. Mr. Pines, we're here for sentencing, correct?
Your Honor, we're here for sentencing in the 21 CF 1190 case.
Yes, sir.
We are working toward a disposition in 21 CF 663 also. I have talked with the state multiple times today, and the original offer for Ms. Glowa was going to be essentially time served. That would
From Ms. Glowa?
For Ms. Glowa,
Okay.
yes.
I don't want to be convicted.
So I have been seeking to see if the state would agree to a withhold. She doesn't really have any prior record here. The state informed me that they would be willing to agree to that if Ms. Glowa agreed to serve 30 more days in the county jail as a condition of probation. Probation would terminate immediately upon her release from custody. Ms. Glowa indicated 10 minutes ago that that was what she was willing to do, and I believe she's now.
No, I just don't want that on my record. So if I have to have that on my record, then there's.
Okay, so we're here for sentencing, right?
Correct, Your Honor.
Okay.
So
what evidence do you want to put on, Mr. Klein?
Well, I'm trying to present the court a unified package here to.
I understand, and I appreciate that, but if it's not going to be that, then I need to make a decision.
Do you want to take one of the state's offers?
Well, the first one, yes, but if there's any way to.
Okay.
For the record thing, then I guess I can't take the adjudication. Adjudication was held, I can't control that, so. I wish there was a way that I could, because I don't
you know, obviously wouldn't want down my regular bill.
What do you want to do? Do you want
I guess the first thing we talked about.
the adjudication and the time served?
Yes, but is it gonna be on my, that's
Yes, it would be on the
forever?
record, yeah.
For the rest of my life?
Mhm.
There's no way that they will do anything else for that?
If you wanted to agree to 30 days in jail. But that would be for a withhold.
Yeah, I'll just take the first one, it is what it is.
The adjudication and time served.
Yeah.
Your Honor, I believe that Ms. Glowa is going to accept the state's first offer in this case, which would be to resolve both cases, which would be, she's already entered the plea in the 1190 case. She would be entering a no contest plea on 21 CF 663 on, I believe, all the counts. I think count 4 would be dismissed, and she would be adjudicated of the felonies. So if the court wants me, I can have Ms. Glowa sign the plea agreements, or if the court wants to take this orally, it's essentially a time served sentence. It's just the adjudication.
Has she read through those with you? Have you gone through those plea agreements with her?
I haven't. I mean, I've gone through the terms with them, but I'm certainly, if the court wants to have her read these plea agreements, I have no problem.
That's fine. I'll do it orally.
Okay. Okay.
To the state. So what you're offering, Ms. Glowa, is an adjudication of guilt, sentence to time served on both cases, and then there would be the court cost, a total of $250 public defender's fee, correct?
That's correct, Your Honor. And just so that we're clear, in exchange for a plea to this, we would dismiss count 4 on,
yes, sir.
On 21 CF 663.
Okay. Ms. Glowa, if you'll raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you, ma'am. You can put your hand down. Ms. Glowa, so do you understand that if I accept your plea, that you're waiving your right to trials by jury?
Yes.
You have to say it verbally.
Yes.
Has anyone forced, threatened, or coerced you into entering the plea?
No.
Okay. Has anyone promised you anything other than what the sentence would be, the adjudication of guilt in both cases and all counts other than count 4 of 21 CF 663? You'd be sentenced to time served. You'd have to pay the court costs and $250 public defender's fee. Anybody promised you anything other than that?
No.
Okay. You have any questions for the court or your attorney or the state?
No.
Are you currently under the influence of any drugs, alcohol, or medication?
No.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No.
Okay. How far did you go in school?
College. Associate's degree.
Okay. Ms. Glowa, and you understand you'll be adjudicated apparently for the first time as a felon, correct?
Yes.
Still wish to enter the plea?
Yes.
Okay. Ms. Glowa, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served other than count 4 of 21 CF 663. That count is dismissed.
And Your Honor, talking with court security, I know that they have a warrant for a failure to appear. I talked with Mr. Gomez, and I know that, or I believe that the state would agree to withdraw that capias. It was for a failure to appear this past Tuesday. I think she was focused on today. So
that's correct, Your Honor. We would withdraw the capias, or agree to withdraw the capias, Your Honor.
The capias is withdrawn. You have to pay the court cost, $250 public defender's fee. How long will it take you to pay? $1,500 or so.
What is the max amount that you're offering?
A year?
Yes.
Okay. So if you fail to pay it within 1 year, then it will go to a civil lien or judgment. Thank you, ma'am.
And Your Honor, I know there was some confusion, but I do have a score sheet for the 1190 case, if I could approach.
Yes, ma'am.
And for the record, the state is offering this because there's about 200 some days of credit she does have.
Thank you.
And as part of this, Your Honor, the state, I believe, would agree to take no action on any failure to appear in any of these cases.
That's correct.
Who's next? Mr. Klein?
Your Honor, I was going to ask the court to sentence Mr. Phillips last so he can spend as much time.
Okay, yes, sir. Mr. McKinnon?
Score sheet for Mr. Young.
Yes, sir.
Your Honor, I have no further business, if I could be excused.
Yes, ma'am. Thank you so much. Have a great weekend.
You too.
Thank you.
Judge, we are running on Mr. Wright. We want to move into that sentencing.
Yes, sir.
Can we approach Your Honor?
Yes, ma'am.
Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hello, Mr. Wright.
How you doing, Your Honor?
Doing well. Thank you, sir.
Judge, this is Mr. Wendell Joseph Wright before the court. Mr. Wright is here in 21 CF 1776. This is scheduled for sentencing today. Mr. Wright was found guilty by a jury of a number of counts. That's what's led us to the sentencing here today. I was provided some character letters, one from Mr. Wright's mother and one from a sister. That was actually provided to my Crestview office this morning. If I don't know if it's even caught up for the court to review that yet.
I haven't seen it, no, sir.
Judge, I provided a copy for the state. May I approach?
Please. Thank you, sir. Thank you. Can you need these copies back?
Judge, those are filed into the record. Those are a copy if the court wishes to keep them or hand them back, whatever the court's pleasure is.
I'm fine giving them back.
And Judge, I did provide a sentencing letter that I emailed to Your Honor. I was holding off on sending that in hopes that I would get those letters from Mr. Wright's family to include with that. Did the court have the benefit of a sentencing letter from Mr. Wright?
I did. I read that yesterday or last night, yes, sir, and highlighted portions.
And Judge, as we move into the details here, pre-sentence investigation was prepared by probation and parole in this case. I did review that with Mr. Wright for make sure that it was accurate. We have no additions or corrections that we are announcing on the record. And we certainly thank probation and parole for the work that they did in putting that together and speaking to all of Mr. Wright's family. In moving into sentencing, this is normally the time where I explain what happened. I don't have to do that here because the court sat through this trial and has a good understanding of exactly what happened. But if we point to the why did this happen, that's the only thing that I can really approach today. And in doing so, I would ask some questions of Mr. Wright if the court wishes to swear Mr. Wright.
Yes, sir. Mr. Wright, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Your Honor, I do.
Thank you, sir. You can put your hand down.
Mr. Wright, could you state your name for the record?
Wendell Joseph Wright.
And let's be honest, you're no stranger to a courtroom.
No, sir, I'm not.
And the state's going to say that you have been to prison before. Is that accurate?
Yes, sir, it is.
Okay. If we look back through the history and the convictions that you have, what is behind all of those things?
Drugs. Addiction.
Have you ever been to an inpatient drug treatment facility to approach those problems in your life?
No, I haven't. No, sir. Never once.
Is that something that you are hopeful that this court will consider?
Yes, something I would love to have. Regardless of anything, I got to do something different.
So, as far as the video that we all watched in the middle of this trial, do you take responsibility for your actions on that day that the jury found you guilty for?
I am a man, and yes, sir, I take those responsibilities. Yeah.
In looking forward, if we're making an argument to the judge of what can we do to ensure that this type of behavior doesn't happen in the future, what is your answer?
Your Honor, I've been incarcerated for a while and had a lot of time without anything to lean to as far as like any addictions or anything, to really take a look at myself. I know what I don't like about me. I don't have a lot left in life. Still a couple people out there that want a relationship with me. I got a mama who she's finally wants a relationship with me. I got a sister. I got a young lady that cares enough about me, sees something different in me. I know what I don't want to do no more. I spent a lot of my life in this. Like he said, I'm no stranger to this. I don't think I ever cared much about my life until now. Your Honor, I need somebody to believe in me. And I won't let you down, or this court system, or even the state. I'd like to make her a different believer in me. I know it looks bad on me, but I need some type of help here.
Mr. Wright, the score sheet that we've reviewed shows 29.1 points. Is that right?
Correct.
Or 29.1 months?
Correct.
So, am I correct in my sentencing letter when I told the court that we're not asking for a downward departure?
Correct.
So we're asking this court to sentence you to the Department of Corrections, sentence you to a guideline sentence, to follow that with probation and ask for that probation to include drug treatment. Is that what we're asking of the court?
Yes, Your Honor. Yes.
Did you do an evaluation with Keaton?
I have.
If accepted into that program, I believe you were accepted into that program.
Correct.
Would you take that for granted if you were awarded that opportunity?
I'm never going to take life for granted again. Correct.
Did you do an application for Phoenix House?
Yes, sir, I did.
If you were accepted into the Phoenix House program, if that was the linchpin for the court in sentencing, would you abide and complete that program?
Yes, I would. Yes, I would, Your Honor.
Now, what else do you think Judge Brown really needs to know? Because he was present at the trial and certainly has the ability to review all of the evidence that came in during that trial. What does he need to know about Wendell Wright?
That I take responsibility. I'm sorry it happened. I went through a lot. And like I said, I probably went through every emotion or trauma you could go through in the street, divorce, the whole nine, and was able to turn to addiction. And then when I was incarcerated all this time, I got to see, and then I got to see it in the trial. That was the first time, and that's not me. There's definitely no history of me doing that type of behavior. Addiction, of course, but not that type of behavior. So definitely something wasn't right, you know. And I need some help.
I have no further questions from Mr. Wright.
Questions from the state?
No questions for Mr. Wright from the state.
Any other evidence, Mr. McKinney?
No, Your Honor, no further evidence, just argument.
Evidence from the state?
Your Honor, the state has record evidence for the court today. I believe Mr. McKinney is going to stipulate to the evidence showing that Mr. Wright is a habitual felony offender. The state has State's Exhibit 1, which is Mr. Wright's penitentiary pack showing that he was last convicted on 10/6/2016 within 5 years, and that he was released from prison on 4/26/2019. It's a certified copy. State also has certified copies of his convictions from 2010 CF 1786, 2010 CF 1787, 2010 CF 1919, 2011 CF 1520, and 2016 CF 1064. They were sentenced together as a violation of probation, but he has his prior convictions so that they are not together. They are actually sequential as required by the statute. The 2011 CF 679 and 2011 CF 1520. So the court will have the benefit of State's Exhibit 1, the pin pack, State's Exhibit 2, the conglomerate of convictions, State's Exhibit 3, 2011 CF 679, State's Exhibit 4, 2011 CF 679 and 2011 CF 1520, and State's Exhibit 5, which is FDLE analysis of the fingerprints from the conglomerate, along with the pin pack with Mr. Wright's booking to show that it is him in all of these. May I approach?
Yes, ma'am. So what are those going to be labeled and admitted as what?
State's Exhibits 1 through 5, Your Honor.
Okay. Any objection, Ms. McKinney?
And as stated by Ms. Sandler, there is no objection to any of these records being introduced as evidence.
So States 1 through 5 are admitted into evidence?
Yes, sir. May I?
Please. Thank you. Thank you, ma'am.
And Your Honor, I believe the record from trial shows that this offense was committed on July 15th, 2021, so it was committed within the time frame required by statute.
Thank you. Any other evidence from the state?
No, Your Honor. The state just asked that the court find that Mr. Wright qualifies as a habitual felony offender for sentencing purposes.
Any objection to that?
Judge, we're not going to stipulate to his HFO status, but given that we have not objected to any of the evidence before the court can so make that designation.
The court designates Mr. Wright as a habitual felony offender. Mr. McKinney, argument?
Judge, has laid out in my sentencing memorandum On the misdemeanor counts, we're asking for time served, given the amount of time that Mr. Wright has spent in jail. He's been in jail since July 15th, 2021. Really, we're talking about a second-degree felony and 2 third-degree felonies. We're asking the court for a guideline sentence structured in a way that includes the drug treatment that Mr. Wright is asking the court for, and deferring to the court in the sentence.
Okay, to the state.
Your Honor, the state has submitted a sentencing letter, but there are some things.
Wait a minute, oh, I don't think I've seen that. No, ma'am. I know.
Your Honor, I have another copy. It was filed with the court.
Okay, it was filed. Okay, I guess, I don't know if I went back and looked in the record or if I was waiting for a sentencing letter to be sent to me, but I didn't ever see one sent to me. When did you prepare it or file
it? Your Honor, it's scanned to the court on the clerk on 9/19/23.
Okay.
Her letter.
I do have a copy here if you're on the
Please.
direct copy.
Yes, ma'am. In the future, if you'll email it directly to me, because I don't know what's in the
I will do so, Your Honor.
And Judge, the defense did have the benefit of reading the state sentencing letter.
Please.
Yeah.
Yes, ma'am. Thank you. Gotcha. To the state, how long was the longest incarcerative sentence for Mr. Wright prior to today?
I believe it was 36 months.
Okay, thank you. Okay, to the state, anything you wish to add in addition to your letter?
Yes, Your Honor.
Please.
I would note that if he did receive a guideline sentence based on the amount that he's been in the Okaloosa County Jail now, he would be in-processed and out-processed fairly quickly. He would not see the inside of the Department of Corrections for very long. Just a matter of days, in fact. What the state needs to note is this would be his 3rd prison sentence if he goes to prison. So obviously the first 2 didn't teach him much of anything because he got out and he committed this offense. Multiple offenses. He was charged with 6 things to begin with. He was acquitted of 2 and convicted of 4. Only today, when he is looking down the barrel of habitual felony offender sentence, is he remorseful. So the why he did it, it doesn't matter. Because he's been drugging it up for years. Since 1999. He's never been to prison for an extended period of time. And it's clear in the PSI.
I thought you said 36 months.
36 months. That's
okay.
Not very long with credit, Your Honor. Mr. McKinney asked what the court needs to know about Wendell Wright. And in the state's opinion, what the court needs to know about Wendell Wright is he's a danger to the community. His actions that day are abhorrent. And the lives he put in danger were over 100. The amount of cars, the court had the benefit of looking in that video, the amount of cars that had to pull over, dodge, stop, get cut off, because Mr. Wright went up and down the wrong way of the highway, not once, but twice. The state went and watched the video. We've watched it several times, trying to count, and we lose count every single time. But what we were able to count was approximately 150. 150 people just going about their business, citizens in our community whose lives were put in danger that day. All because he just didn't want to get pulled over. That's who Mr. Wright is. That's the behavior that he's shown this court. Mr. Wright asked today for drug treatment and a guideline sentence. He's been offered drug treatment several times and has never availed himself of it. Never. He keeps violating probation. That's what he does. He violates, he's gone to prison. He violates, he's gone to prison.
So terms of some of his prior supervision included drug rehab or?
Drug treatment, Your Honor.
Drug treatment?
Yes,
Okay.
and he was even offered the opportunity, I believe, once to go to drug court. He was caught with methamphetamine and a significant amount of paraphernalia in this case. And his record shows he's never been concerned with being a law-abiding citizen. No matter what he's presented to the court today, and these letters asking the court to show mercy, the citizens of Okaloosa County have been terrorized enough. The courts have already shown Mr. Wright mercy, and he's abused the privilege long enough. This is a matter at this point of protecting the public. What sentence will protect the public with Mr. Wright's history and his designation as a habitual felony offender? And he needs to be sentenced in a manner commensurate with the degree of protection that the public deserves at this point. The purpose of sentencing is punishment. Can the court sentence Mr. Wright as a habitual felony offender? The court can. The court has designated him such. Should the court sentence Mr. Wright as a habitual felony offender? With this offense, absolutely. A guideline sentence is not a punishment for Mr. Wright. A habitual felony offender sentence is a punishment for Mr. Wright. So the state asks the court to sentence Mr. Wright to the maximum sentence allowable by law, because that is what he deserves for this offense. Thank you.
Mr. McKinney, finally?
Judge, may I put the score sheet?
Yes, sir. Please, thank you. You can have that copy back. Thank you, that's yours. Thank you.
Judge, this isn't a fancy argument for downward departure. We're asking the court to give Mr. Wright a guideline sentence and follow that with what's actually going to put Mr. Wright in a position to have the tools to move forward in life. The state has indicated that he has had drug treatment in the past. He has never been sentenced or had the opportunity for an inpatient drug treatment facility ever in his life. If he had, we may not be here. I think Mr. Wright is sincere in his request. He's been accepted into the Keaton program. We applied in August for Phoenix House, but we don't have an answer back yet. So I cannot represent to the court that he has a bed waiting at Phoenix House. He does at Keaton. So we're asking the court to consider that in a sentencing structure.
Thank you. As I look at the PSI, they have a sentence in there that says, due to the defendant's poor record, it does not appear that he can complete a community sanction. But then in conjunction of that, they recommend the lowest permissible prison sentence in months. And I certainly wonder if they, before they made their recommendation, if they saw those videos or that video. I don't know how much that PSI really is to the court as far as the recommendation. Mr. Wright, I referred earlier today to one of the Florida Supreme Court justices that spoke at the bar meeting on Monday night. And I asked him a question, and it relates to your case. In every case, and I wasn't asking him just for your case, but every case, and I said, how do you see mercy figuring into the sentencing of a criminal defendant? And it was really interesting, and he said something that I believe. He said, you know, it figures into your discretion. Trial courts have, as you can tell by this latitude, got a huge area of discretion. But one thing that he said that I had never consciously thought about, I always thought about the victim's rights and justice in relation to the victims. He said, you also have to take into consideration mercy toward the victims, whether it's the victim's families, those things. Very interesting, because I had, you know, thought a lot about mercy in relation to the defendant, but never used that word in relation strictly to the victim or victim's family. Again, thought of justice and those things. So it is interesting. So as far as the breakdown, what are the maximums I can give? And Mr. Wright, don't freak out when I say maximums. I'm just trying to figure out my latitude, my discretion. What are the maximums I can sentence Mr. Wright to in each count? So I understand the misdemeanors would be time served, but in count one?
Is a second-degree felony, Judge?
Yes,
Typically, that would be a maximum sentence of 15 years in the Department of Corrections. If sentenced as HFO, that would double exposure.
I understand.
It's listed as count 4, but the grand theft auto is a third-degree felony, which is typically punishable by a maximum of 5 years in the Department of Corrections, which would also double exposure with HFO. And possession of controlled substance is a third-degree felony, punishable by a maximum of 5 years in prison, which is also can be doubled by HFO.
Thank you. Mr. Wright, you're adjudicated guilty. You're sentenced to 15 years with the Department of Corrections with credit for time served on count 1. And that's followed by 7 years of probation in both counts 4 and 7. Those are to run concurrently, run at the same time. You will need to enter and successfully complete the Keaton program. If when you get out, there isn't a Keaton program, then it'd have to be a comparable program. You do have credit for all time served on the incarcerative sentence. You'll need to pay the court costs, the public defender's fee, your sentence to time served on the misdemeanors. I want you to be a productive, sober citizen the same way that you say you do. Love to have to do something different, need someone to believe in me. I believe in you, but you got to be sober to do that. I've got to keep society between now and then, so I really hope that you succeed. You do have 30 days to appeal this judgment and sentence. If you do need to file an appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, Your Honor.
Yes, ma'am.
Your Honor, we're asking the court to also order restitution.
Thank you, ma'am.
And
that was in your letter.
As outlined in the PSI.
Okay, and I think it's also in your letter too, correct?
I believe so, sir.
Okay. I do order restitution in the amount of $28,177.45 to the Okaloosa County Sheriff's Office, $4,295.58 to Kayla Jackson, and the court does award restitution to Jessica, and it's BARRAVECCHIO. I award restitution to her, but reserve jurisdiction for 90 days if the state files a motion or a petition. Again, all monetary assessments mandated by statute or county ordinance are imposed. That's the court costs. Have to pay the public defender's fee, the cost of supervision. However, the cost of supervision would be waived while Mr. Wright is in Keaton or another comparable program.
Yes, sir.
Thank you, sir. Good luck, Mr. Wright.
Judge, the court will see Mr. Wright on November 13th for pretrial on his remaining cases.
Thank you. Madam Clerk's asking if I sentenced him as an HFO. I didn't go over the, well, I did go over the cap, so I did sentence him as an HFO.
Okay, I just want to make sure
Yes,
for the JNS purposes.
Yes, ma'am. Thank you. I appreciate it. Okay, who's next?
Your Honor, that completes my business with the court. May I be excused?
Yes, ma'am. Thank you. Have a great weekend.
You too.
Thank you.
Your Honor, I have Mr. Phillips. He's present for sentencing, but in speaking with Mr. Phillips just now, he and his girlfriend are actually in the process of getting married. And are you waiting for the license, or you got to apply for it? They've actually already applied for a marriage license. Mr. Phillips is here. I know the court will be here next week on certain jury trials. I don't know how accurate this is, and I've certainly never done this, but I believe that they would have to have a marriage license in hand, but I think that the court could officiate the wedding if necessary. What I'm asking
I've
is...
tried to get out of that business, so I've done very little of that.
I've never done it before, so I said, I just kind of made a comment like that would be a career highlight for me to arrange a wedding. Mr. Phillips is going to ask if the court would consider extending this sentencing until next week at the first available date next week, so he could get that marriage license, and I could look into what the mechanics are of having this performed. But he is here. He is ready to be sentenced, but given the fact that he's trying to marry his girlfriend at this point, he would just ask the court to give him another couple of days so he can get that marriage license.
One, Mr. Phillips, it means a lot that you're here. I appreciate you being here to this state.
The state's gonna have to respectfully object to this, Your Honor. We'll leave it in the court's discretion. Obviously, it's completely up to you. Our take is that, if I'm not mistaken, this wasn't the first time that we had continued the sentencing.
No, we had set this for, he had pled at the beginning of August, and this was the first day that he's come in.
I'm gonna have to respectfully object, Your Honor. We would like for him the sentence to be imposed today. However, obviously, we defer to your discretion.
Your Honor, I was just informing Mr. Phillips, if the court elects to impose a sentence today, I'll talk with his fiancée and see if I could have Mr. Phillips transported to court sometime next week, maybe. If the court would be willing to consider that. Again, this is so out of left field. Last thing I would have thought I would have been talking about today.
Well, and any notary, the clerk has the power to do that.
So, but my understanding is that I think he has to be physically present in front of a judge, but to make that happen. So, I'll have to look into that. Like I said, this is.
Or a religious leader.
Yeah, I mean, there are a lot of people that have the ability. You can get a license online. My wife did, in order to perform that service. So I'm not downplaying it. Certainly, I think I would be conflicted out of that in this arena.
Understood.
And again, I'm trying to get out of that.
Yes, sir. He is present for sentencing. I will go ahead and talk with Ms. Allen and see if I can help arrange this in any way, shape, or form. But if the court wants to proceed to sentencing, you agreed upon sentences in the plea agreement.
Yes, sir.
Does the court need a copy of the plea agreement?
No, sir, I've got it. This is where that Supreme Court justice goes. You know, they're amazed at what the trial courts do because of the discretion that you have.
Understood.
Mr. Phillips, remind me of how long you've lived in the area?
My whole life. Well, since second grade. My parents both work for the school board.
Okay. So next week, the first day that we would have court would be Thursday.
I can, 8:30? Well, you're picking a jury that day, right?
Right, but I mean, it wouldn't take long to do that. Mr. Phillips, I'll see you back here on Thursday, a week from today, the 28th at 8:30, okay? Just remember the same thing that we talked about before. If you fail to come back here then, you could be sentenced up to, well, there's life in prison.
The next one. Yes, sir.
Judge, the state's going to request, because that's an exception, like that's the date of trial. He needs to be here at 8:30, not 8:35, not 8:31.
That is fair. That is fair, and I was going to instruct Mr. Phillips, 8:30 means 8:25.
Mr. Phillips, we're going to have the jury members waiting on us. A lot of things. You need to be in the courtroom at 8:30. Okay. So
Question.
Yes, sir.
Should I wait on
I'm
getting a clerk or somebody to do that?
I'm going to call you tomorrow morning.
Or should we just do it?
I'm going to call you tomorrow morning as soon as I get to the office.
If you want to get married, you need to get married before 8:30
I was going to
on
say,
Thursday.
Yeah, I was going to say,
Okay.
I think you guys can just come down to the clerk's office once you have the license, and there you go.
All right, thank
I think so too.
But
We'll
we'll
see
talk
you
tomorrow.
then.
Okay.
Appreciate it. Thank you, sir. Okay. What else do we have, Madam Clerk? Okay. Thank you, everyone. Do you have anybody else in the gallery that's?
No, Judge, they're all here with Mr.
Okay.